Lawyers. What are the 45 most shocking lawsuits that changed everything in the 1800s? Case 1. Marbury v. Madison, 1803. In the final hours of President John Adams's administration, he appointed William Marbury as a justice of the peace. When incoming President Thomas Jefferson instructed his Secretary of State, James Madison, to withhold Marbury's commission, Marbury sued. Chief Justice John Marshall faced a political minefield. Ordering Madison to deliver the commission would likely be ignored, but dismissing the case would appear weak. Marshall's brilliant solution established the most fundamental principle in American constitutional law. The court ruled that while Marbury had a right to his commission, the section of the Judiciary Act that gave the Supreme Court original jurisdiction in such cases was unconstitutional. In declaring an act of Congress void for the first time, Marshall established judicial review, the power of the Supreme Court to declare laws unconstitutional. This transformed the judiciary into a co-equal branch of government with the authority to interpret the Constitution as the supreme law of the land. The decision fundamentally shaped the American system of checks and balances. Case 2. Fletcher v. Peck, 1810. Georgia's legislature became embroiled in one of the most egregious corruption scandals in early American history. In 1795, Georgia sold 35 million acres of western lands, known as the Yazoo lands, to 4 land companies for the bargain price of $500,000. Nearly every legislator who voted for the sale had been bribed with company stock or cash. When voters discovered the corruption, they swept the guilty legislators from office. The new legislature promptly passed the Yazoo Rescinding Act of 1796, voiding all the previous land grants. However, much of the land had already been sold to innocent third parties, including John Peck, who later sold some to Robert Fletcher. When Fletcher sued Peck claiming defective title, the case reached the Supreme Court. Chief Justice John Marshall ruled that despite the fraud, Georgia could not rescind the land grants because doing so violated the Constitution's contract clause. This marked the first time the Supreme Court struck down a state law as unconstitutional. The decision established that contracts, once made, create vested rights that states cannot impair, even to correct their own corruption. Case 3. Martin v. Hunters, Lessee, 1816. Lord Fairfax, a British loyalist, owned vast tracts of land in Virginia. When he died, his will left the land to his nephew in England. During the Revolutionary War, Virginia seized the Fairfax estate, claiming it could confiscate property belonging to British subjects. The state then sold portions of the land. Denny Martin, Fairfax's heir, sued David Hunter, who had purchased land from Virginia claiming federal treaties protected his inheritance. The Virginia Supreme Court of Appeals ruled for Hunter, declaring that the federal Supreme Court had no authority to review state court decisions. This challenge struck at the heart of federal power. Justice Joseph Story, writing for the Supreme Court, issued a sweeping defense of federal judicial authority. He ruled that the Constitution's Supremacy Clause and the Judiciary Act of 1789 explicitly gave the Supreme Court appellate jurisdiction over state court decisions involving federal law. The court held that uniform interpretation of federal law required a single supreme arbiter. This landmark decision established the Supreme Court's power to review and overturn state court rulings, preventing individual states from independently interpreting federal law. Case 4. McCulloch v. Maryland, 1819. After the War of 1812, Congress chartered the Second Bank of the United States to stabilize the national economy. Many states, including Maryland, opposed the bank and passed laws to tax it out of existence. When James McCulloch, cashier of the Baltimore branch, refused to pay Maryland's tax, the state sued. Maryland argued that the Constitution didn't explicitly grant Congress the power to create a national bank, and even if it did, states could tax federal institutions within their borders. Chief Justice John Marshall delivered one of the most important opinions in constitutional history. He ruled that the Constitution's necessary and proper clause gave Congress implied powers beyond those explicitly listed, declaring, "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate are constitutional." Marshall then held that the power to tax involves the power to destroy, and states cannot tax federal institutions. This decision established two fundamental principles: the doctrine of implied powers, allowing the federal government to adapt to changing circumstances, and federal supremacy over state governments in areas of federal authority. Case 5. Dartmouth College v. Woodward, 1819. Dartmouth College, a private institution founded by royal charter in 1769, became a battleground for control between the college's original trustees and New Hampshire's state government. The college's longtime president died, and political factions fought over his replacement. In 1816, New Hampshire's legislature passed laws converting Dartmouth from a private college into a state university, adding new trustees, and changing the institution's governance. The original trustees, led by College Secretary William Woodward, challenged these laws. Daniel Webster, representing the college, delivered an emotional argument before the Supreme Court, concluding with the famous plea, "It is, sir, as I have said, a small college, and yet there are those who love it." Chief Justice Marshall ruled that Dartmouth's colonial charter was a contract protected by the Constitution's contract clause. States could not unilaterally alter the terms of corporate charters. This decision had profound implications beyond education, establishing the sanctity of private contracts and corporate charters, protecting businesses from arbitrary state interference, and encouraging economic development by assuring investors their rights would be protected. Case 6. Sturges v. Crowninshield, 1819. Richard Crowninshield, a struggling merchant in New York, borrowed money from Josiah Sturges. When Crowninshield couldn't repay the debt, he sought relief under New York's bankruptcy law, which allowed debtors to discharge their obligations if they surrendered their property. Sturges sued, arguing the state law violated the Constitution's contract clause. The case raised a critical question: could states pass bankruptcy laws that impaired existing contracts? Chief Justice Marshall acknowledged that the Constitution gave Congress the power to establish uniform laws on the subject of bankruptcies, but Congress hadn't yet exercised that power. The court ruled that while states could pass prospective bankruptcy laws for future contracts, they couldn't pass laws that impaired obligations of contracts already made. The decision clarified the relationship between state bankruptcy laws and federal constitutional protections. It reinforced the principle that contract rights, once established, were protected from state interference. The ruling forced states to carefully craft their bankruptcy legislation and ultimately encouraged Congress to take a more active role in creating uniform bankruptcy laws that would apply nationwide. Case 7. Cohens v. Virginia, 1821. Brothers Philip and Mendez Cohen were convicted in Norfolk, Virginia, for selling District of Columbia lottery tickets in violation of Virginia law. The Cohens argued they were immune from state prosecution because Congress had authorized the D.C. lottery. Virginia's legislature, still angry over the Supreme Court's decisions in Martin v. Hunter's Lessee and McCulloch v. Maryland, instructed its attorneys to argue solely that the Supreme Court lacked jurisdiction to review state criminal convictions. Virginia claimed the 11th Amendment barred federal courts from hearing cases against states, and that allowing federal review of state court decisions would destroy state sovereignty. Chief Justice Marshall, writing for a unanimous court, delivered a powerful defense of federal judicial power. He held that the Constitution's grant of judicial power extended to all cases arising under federal law, regardless of whether a state was a party. Marshall declared that without federal review, each state would become its own interpreter of federal law, potentially destroying the Union. The court ruled it had jurisdiction, though it ultimately decided Virginia's law was valid. This decision definitively established the Supreme Court's authority to review state court decisions in criminal cases involving federal questions. Case 8. Gibbons v. Ogden, 1824. New York State granted Robert Livingston and Robert Fulton exclusive rights to operate steamboats in New York waters, creating a monopoly. Aaron Ogden purchased a license from them to run a steamboat ferry between New York and New Jersey. Thomas Gibbons, his former partner, began competing with Ogden using a federal coastal trading license. Ogden sued to enforce New York's monopoly grant. The case became a monumental battle over federal versus state power. Chief Justice Marshall delivered a sweeping opinion defining commerce broadly, to include all commercial activity between states, not just buying and selling. He ruled that Congress's power to regulate interstate commerce was complete and supreme, leaving no room for conflicting state regulations. New York's steamboat monopoly laws directly contradicted federal authority and were therefore unconstitutional under the Supremacy Clause. The decision broke up entrenched monopolies, fostered competition and innovation in transportation, and established federal commercial power as paramount. It laid the foundation for an integrated national economy and remains one of the most cited cases in Commerce Clause jurisprudence. Marshall's broad interpretation of commerce gave Congress authority to regulate countless future economic activities. Case 9, Osborne v. Bank of the United States, 1824. Following the Supreme Court's decision in McCulloch v. Maryland, Ohio, defied federal authority by imposing a tax on the Bank of the United States. Ralph Osborne, Ohio State Auditor, forcibly entered the bank's Columbus branch and seized over $100,000 in state taxes, depositing it in the state treasury. The bank sued Osborne and other state officials to recover the money. Ohio argued that the 11th Amendment's prohibition against suits against states also barred suits against state officials acting in their official capacity. The Supreme Court disagreed, establishing a crucial principle that would echo through civil rights cases for generations. Chief Justice Marshall ruled that while states themselves enjoyed sovereign immunity, individual state officers who violated federal law could be sued, even when acting in their official capacity. The court ordered Ohio to return the seized funds. This decision created what became known as the Ex parte Young Doctrine, allowing federal courts to enjoin state officials from enforcing unconstitutional state laws. It prevented states from using sovereign immunity as a shield for violating federal law and ensured that federal rights could be meaningfully enforced against state action. Case 10, Johnson v. McIntosh, 1823. Thomas Johnson purchased land directly from the Piankeshaw Indians in 1773 and 1775. After the Revolutionary War, the United States government sold the same land to William McIntosh. When Johnson's heirs tried to claim the land, the case raised fundamental questions about Native American land rights. Chief Justice Marshall faced the difficult task of reconciling European conquest with legal principles. His decision created the doctrine of discovery, which fundamentally shaped Native American law for 2 centuries. Marshall ruled that European nations, through discovery, had gained title to Native American lands, though tribes retained a right of occupancy. Most controversially, the court held that Native Americans could not sell their land to private individuals, only to the federal government. Marshall acknowledged this outcome rested more on power than justice, writing that conquest gave exclusive title to those who made it. The decision established that Native American sovereignty was limited. Tribes were domestic dependent nations, and their property rights were subordinate to federal authority. While Marshall attempted to protect some tribal rights, the decision's framework justified centuries of land dispossession and remains contentious today as tribes continue fighting for recognition of their original land rights. Case 11, Wheaton Fowson Peters, 1834. Henry Wheaton served as the Supreme Court's official reporter, publishing volumes of court opinions with his notes and commentary. After his tenure ended, his successor Richard Peters began publishing a condensed compilation that included Wheaton's work. Wheaton sued for copyright infringement, claiming ownership over the court opinions he had reported. This case forced the court to confront fundamental questions about copyright that had never been addressed. Justice McLean's opinion established several lasting principles. First, that copyright is not a natural right but a privilege created by statute, subject to specific requirements. Second, that federal court opinions themselves cannot be copyrighted. They are public property. Third, that compliance with statutory formalities, like registration and deposit, was mandatory for copyright protection. Wheaton had failed to properly register some volumes, forfeiting protection. The decision balanced public access to the law against authors' rights to their original contributions. It established that while legal documents themselves must remain freely available, the annotations, commentaries, and arrangements added by reporters could potentially be protected. This distinction remains relevant today in debates over access to legal information. Case 12, Charles River Bridge v. Warren Bridge, 1837. In 1785, Massachusetts granted the Charles River Bridge Company a charter to build and operate a toll bridge between Boston and Charlestown. The bridge was immensely profitable. Decades later, in 1828, the legislature chartered the Warren Bridge Company to build a free bridge just 825 feet away. Once construction costs were recovered, the Warren Bridge would become free to the public. The Charles River Bridge Company sued, claiming its original charter implied an exclusive right to bridge the river, and the new charter violated the Constitution's contract clause. Daniel Webster argued for the old bridge company that competition would destroy their investment. Chief Justice Roger Taney, John Marshall's successor, took a dramatically different approach to contracts than his predecessor. Taney ruled that public grants must be construed narrowly, ambiguities should favor the public, and exclusive rights must be explicitly stated. The old charter nowhere mentioned exclusivity. Taney emphasized that monopolistic interpretations would stifle progress and innovation, trapping society with outdated infrastructure. This decision marked a philosophical shift toward balancing property rights with public welfare and economic development, encouraging state governments to promote competition and innovation over protecting established monopolies. Case 13, New York v. Milne, 1837. New York passed a law requiring ship captains to report information about arriving passengers and to post bonds for anyone likely to need public support. George Milne, a ship captain, challenged the law as an unconstitutional regulation of interstate and foreign commerce, powers reserved exclusively to Congress under the Commerce Clause. New York defended its law as a valid exercise of police powers to protect residents' health, safety, and welfare. The case came before the Supreme Court during a transition period. Marshall had died, and the court under Chief Justice Taney was developing its own approach to federalism. Justice Barber, writing for the majority, upheld New York's law, ruling that states retained police powers to protect their citizens' welfare, even if such regulations incidentally affected commerce. The decision created a framework for determining when state laws were valid exercises of police power versus impermissible intrusions on federal commercial authority. This case began developing the distinction between regulations primarily concerned with commerce, requiring federal action, and those primarily concerned with local safety, health, and welfare, permissible state action. The tension between these principles would drive constitutional debates for decades. Case 14, Bank of Augusta v. Earl, 1839. The Bank of Augusta, chartered in Georgia, conducted business in Alabama by purchasing bills of exchange. When Joseph Earl and other Alabama citizens refused to pay on the bills, the bank sued. Defendants argued that as a Georgia corporation, the bank had no legal right to conduct business in Alabama without explicit permission from Alabama's legislature. This raised the critical question: could corporations created in one state operate in another? The case threatened to fracture the emerging national economy, as corporations were becoming crucial to economic development. Chief Justice Taney's decision struck a careful balance. He ruled that corporations were not citizens under the Constitution's Privileges and Immunities Clause, so states could exclude foreign corporations. However, once a corporation is permitted to do business in a state, principles of comity, mutual respect between states, prevent arbitrary discrimination. States couldn't discriminate against out-of-state corporations without legitimate justification. Taney established that states had power to exclude foreign corporations, but would be presumed to permit them unless explicitly prohibited. This decision provided the foundation for interstate corporate activity while preserving state sovereignty, enabling the growth of a national commercial market. Case 15, Swift v. Tyson, 1842. George Tyson purchased land in Maine using a bill of exchange, essentially a promissory note. The land deal was fraudulent, but Tyson's bill of exchange had been negotiated to Swift, a New York resident who claimed to be an innocent purchaser for value. Swift sued Tyson in federal court. New York state courts had ruled that even innocent purchasers took bills subject to underlying fraud defenses. The case required the federal court to decide whether to follow New York's interpretation or create its own rule. Justice Story, writing for the court, made a fateful decision. He ruled that while the Judiciary Act of 1789 required federal courts to follow state statutes, it didn't require following state court decisions on general commercial law. Instead, federal courts could develop their own common law principles. This created a dual system. State courts followed state law, while federal courts followed federal common law. For nearly a century, this doctrine allowed federal courts to develop uniform commercial rules, promoting interstate business. However, it also created inconsistency. The same issue could be decided differently depending on which court system heard it. The decision lasted until 1938, when Erie Railroad v. Tompkins overruled it, holding that there is no general federal common law. Case 16, Prigg v. Pennsylvania, 1842. Margaret Morgan, born into slavery in Maryland, escaped to Pennsylvania with her children in 1832 in 1837. Edward Prigg, acting as an agent for Morgan's purported owner, captured Morgan and her children without legal process and returned them to Maryland to be sold. Pennsylvania charged Prigg with kidnapping under its personal liberty law of 1826, which required slave catchers to obtain judicial approval before removing alleged fugitives. The case forced the Supreme Court to confront the explosive issue of fugitive slaves. Justice Story, despite his personal opposition to slavery, ruled that the Constitution's Fugitive Slave Clause and the Federal Fugitive Slave Act of 1793 gave slave owners an absolute right to recapture fugitive slaves.
Pennsylvania's law,
Requiring additional procedures, was unconstitutional as it conflicted with federal power. However, Story included a crucial caveat. While the federal government could enforce fugitive slave laws, it couldn't compel state officials to assist. This led northern states to pass new laws prohibiting state resources from being used to capture fugitive slaves, effectively nullifying the Fugitive Slave Act in many areas. The decision inflamed sectional tensions, contributing to the more stringent Fugitive Slave Act of 1850 and moving the nation closer to civil war. Case 17, United States v. the Amistad, 1841. In 1839, Portuguese slave traders kidnapped approximately 500 Africans from Sierra Leone and transported them to Cuba, where Spanish planters purchased 53 of them despite Spain's ban on the African slave trade. Aboard the schooner Amistad, the Africans, led by Sengbe P.A., Joseph Sink, revolted, killed the captain and cook, and ordered the crew to sail to Africa. The crew deceived them, sailing north to Long Island, where the U.S. Navy seized the ship. President Martin Van Buren, under pressure from Spain, ordered the Africans returned for trial and execution. The case became a national sensation and a rallying point for abolitionists. The district court ruled the Africans were free, having been illegally enslaved. On appeal, former President John Quincy Adams, then 73 and serving in Congress, argued passionately before the Supreme Court for 8.5 hours. Justice Story's opinion held that the Africans had been kidnapped in violation of Spanish law and treaties banning the slave trade. Never having been legally enslaved, they were free persons who had exercised their natural right to resist unlawful captivity. The decision freed the survivors, who returned to Africa in 1842, and demonstrated that even in pro-slavery America, justice could occasionally prevail. Case 18, Cherokee Nation v. Georgia, 1831. In 1828, Georgia passed laws extending state authority over Cherokee lands, nullifying Cherokee government and opening their territory for white settlement. The Cherokee Nation, under Principal Chief John Ross, had established a written constitution and functioned as a sovereign nation. Rather than resort to violence, they hired former Attorney General William Wirt and filed suit directly in the Supreme Court, seeking an injunction to prevent Georgia's laws from taking effect. The Cherokee argued they were a foreign nation under the Constitution, giving the court jurisdiction. Chief Justice Marshall faced intense political pressure, as President Andrew Jackson supported Georgia's position in Indian removal generally. Marshall crafted a compromise opinion that disappointed both sides. He held that while the Cherokee were a distinct political society capable of self-government, they were not a foreign nation, but rather a domestic dependent nation existing under the guardianship of the United States. Their relationship to the federal government resembled that of a ward to his guardian. Because they weren't a foreign nation, the court lacked jurisdiction to hear their suit. While Marshall's opinion preserved some theoretical basis for tribal sovereignty, it provided no immediate relief and left the Cherokee vulnerable to Georgia's actions. Case 19, Worcester v. Georgia, 1832. After Cherokee Nation v. Georgia failed to protect Cherokee rights, Georgia intensified its assault on tribal sovereignty. The state passed a law requiring all white people living in Cherokee territory to obtain a license and swear loyalty to Georgia. Samuel Worcester, a missionary who had been advising the Cherokee on resisting Georgia's encroachments, refused. He was arrested, convicted, and sentenced to 4 years hard labor. Worcester appealed, and this time the jurisdictional obstacle that had barred the earlier case didn't exist. Worcester was not a tribe, but an American citizen, giving the court clear jurisdiction. Chief Justice Marshall seized the opportunity to vindicate Cherokee sovereignty. His opinion declared that the Cherokee Nation was a distinct community, with territorial boundaries guaranteed by federal treaties. Georgia's laws violated these treaties and exceeded state authority. Worcester was released. The court ruled that only the federal government, not states, could regulate affairs with Indian nations. Marshall famously wrote that Georgia's laws are in direct hostility with treaties, and with the acts of Congress, they are in direct violation of the Constitution. President Jackson reportedly responded, "John Marshall has made his decision. Now let him enforce it." Georgia ignored the ruling, and Jackson refused to enforce it, revealing the limits of judicial power without executive support. The decision ultimately failed to prevent Cherokee removal on the Trail of Tears. Case 20, Barron v. Baltimore, 1833. John Barron owned a profitable wharf in Baltimore's harbor. The city undertook public works projects that diverted streams, causing sand and silt to accumulate around Barron's wharf, making the water too shallow for ships. Barron's business was destroyed. He sued Baltimore, claiming the city had taken his property without just compensation in violation of the Fifth Amendment. Maryland courts ruled against him, and he appealed to the Supreme Court. The case raised a fundamental question about the reach of the Bill of Rights. Chief Justice Marshall delivered what seemed like a straightforward opinion, but with enormous consequences. He ruled that the Bill of Rights, including the Fifth Amendment's requirement of just compensation, applied only to the federal government, not to state or local governments. The Constitution's structure, Marshall explained, made clear that limitations on power apply only to the government that granted them. Since the Bill of Rights was added to the federal Constitution, it restrained only federal action. States remained free to violate rights protected in the Bill of Rights unless their own state constitutions prohibited such actions. This decision meant Americans' fundamental rights depended entirely on state protection. The ruling stood for over 130 years until the 14th Amendment, and the doctrine of incorporation gradually applied most Bill of Rights protections against states. Case 21, Abelman v. Booth, 1858. Sherman Booth, a Wisconsin abolitionist and newspaper editor, helped rescue Joshua Glover, a fugitive slave, from federal custody in Milwaukee. Federal authorities arrested Booth for violating the Fugitive Slave Act of 1850. The Wisconsin Supreme Court issued a writ of habeas corpus ordering Booth's release, declaring the Fugitive Slave Act unconstitutional. This created a direct confrontation, a state Supreme Court claiming authority to overrule federal law and free a federal prisoner. Chief Justice Taney, writing for a unanimous Supreme Court, issued one of the strongest assertions of federal judicial supremacy in the court's history. He ruled that state courts had no power to interfere with federal court proceedings or federal prisoners. The Fugitive Slave Act was constitutional. Most significantly, Taney held that state courts couldn't issue writs of habeas corpus to release federal prisoners or review federal court judgments. The Constitution and the Supremacy Clause made federal law supreme, and only federal courts could determine its validity. While the decision reinforced federal judicial authority and prevented states from nullifying federal laws they opposed, it also upheld one of the most despised laws in American history. The irony is sharp. Taney's opinion defending federal supremacy came from the same justice who had authored Dred Scott the previous year, one of the court's most reviled decisions. Case 22, License Cases, 1847. 3 separate cases from Massachusetts, Rhode Island, and New Hampshire challenged state laws regulating the sale of alcohol. States had passed these laws under their police powers to promote temperance and public morality. Merchants argued that alcohol was an article of interstate and foreign commerce, so states couldn't regulate its sale without violating Congress's exclusive commerce power. The cases presented difficult questions about the boundaries between state police powers and federal commerce power. Chief Justice Taney and the justices struggled to articulate a clear standard, ultimately producing 6 separate opinions with no majority reasoning. However, they agreed on the outcome. States could regulate alcohol sales, even though alcohol was an article of commerce. The court reasoned that protecting citizens' health, safety, and morals fell squarely within states' police powers, even if such regulations affected commerce. States weren't regulating commerce itself, but rather its local incidents and effects. The fractured opinions reflected deep disagreement about how to balance state and federal power. These cases contributed to the development of the police powers doctrine, recognizing that states retained authority over matters of local concern, even in areas touching interstate commerce. The lack of clear doctrinal guidance, however, meant courts would struggle with these issues for decades. Case 23, Passenger Cases, 1849. New York and Massachusetts imposed taxes on each passenger arriving by ship from foreign countries or other states. The states claimed these taxes funded programs to care for indigent immigrants. Ship owners challenged the taxes as unconstitutional regulations of interstate and foreign commerce. The Supreme Court struck down both state laws in a 5-4 decision with 8 separate opinions. The majority concluded that the passenger taxes were regulations of commerce, which only Congress could impose. However, the justices couldn't agree on the reasoning. Some argued the taxes impermissibly regulated commerce itself. Others focused on foreign affairs, suggesting that state taxes on foreign passengers interfered with federal control over immigration and international relations. Justice Wayne noted that if individual states could tax or exclude foreign arrivals, they could undermine foreign policy or create international incidents. The dissent argued that the taxes were valid exercises of police power to protect citizens from disease and poverty brought by immigrants. The case highlighted the tension between state sovereignty and national uniformity in an era of mass immigration. While it prevented states from directly taxing immigration, it left many questions unanswered about what other regulations states could impose. The passenger cases foreshadowed continuing battles over immigration policy and federal-state relations. Case 24, Luther v. Borden, 1849. Rhode Island's colonial charter served as its state constitution until 1841, the only state still using a colonial-era document. The charter imposed property requirements for voting, excluding most of the population. Thomas Dorr led a reform movement that held an unauthorized convention, drafted a new constitution, and established a rival people's government. When Dorr's followers attempted to seize state buildings, the charter government declared martial law and called out the militia. Luther Borden, acting under martial law authority, broke into Martin Luther's home searching for weapons. Luther sued Borden for trespass. Luther claimed the charter government was illegitimate, so Borden had no lawful authority. The case raised profound questions. Who decides what government is legitimate? Can courts resolve such disputes? Chief Justice Taney held that these were political questions beyond judicial authority. The court couldn't decide which of 2 rival governments was legitimate, that power belonged to Congress and the president. When the president recognized the charter government and sent federal troops to support it, that determination was conclusive. The court also refused to review the governor's decision to declare martial law as such determinations involve discretion beyond judicial review. This established the political question doctrine, holding that some issues are inherently non-justiciable and must be resolved by political branches. Case 25, Cooley v. Board of Wardens, 1852. Philadelphia's Board of Wardens required ships entering or leaving the port to hire local pilots or pay a fee. Aaron Cooley, representing ship owners, refused to comply, arguing Pennsylvania's law unconstitutionally regulated interstate and foreign commerce. The case presented the fundamental question: if commerce power resided in Congress, could states regulate commerce at all? Justice Curtis's opinion created a lasting framework. He distinguished between subjects requiring uniform national regulation and those permitting diverse local regulation. Some commercial subjects were national in nature, requiring uniform rules across states. Only Congress could regulate these. Other subjects were local, where diverse state rules were appropriate and even necessary. States could regulate these unless Congress acted. Pilotage, Curtis concluded, was an inherently local matter where uniform national rules were impractical. Different ports had different hazards requiring specialized local knowledge. Pennsylvania's law was therefore constitutional. The Cooley Doctrine provided a middle path between extremes. Commerce wasn't exclusively federal or exclusively concurrent. Whether states could regulate depended on the subject's nature. If Congress wanted to occupy the field on local matters, it could do so through legislation. This case gave courts a framework for deciding countless future challenges to state commercial regulations, though determining which subjects were national versus local proved endlessly controversial. Case 26, the Prize Cases, 1863. When Confederate forces fired on Fort Sumter in April 1861, President Abraham Lincoln faced a constitutional crisis. Congress wasn't in session, and the Constitution grants only Congress the power to declare war. Nevertheless, Lincoln proclaimed a naval blockade of southern ports, treating the Confederacy as a belligerent power at war with the United States. Union naval forces seized ships attempting to run the blockade, claiming them as prizes of war. Ship owners sued, arguing that without a congressional declaration of war, no state of war existed, making the seizures illegal piracy. The Supreme Court confronted a profound question: could the president unilaterally recognize and respond to war without congressional approval? Justice Greer, writing for a narrow 5-4 majority, upheld Lincoln's actions. The court held that while only Congress could declare war against foreign nations, the president could recognize when war had been thrust upon the nation through invasion or rebellion. Lincoln didn't initiate war, the Confederacy did. As commander-in-chief, the president had authority and duty to respond immediately to armed insurrection without waiting for Congress to meet. The blockade was a legitimate exercise of war powers. This decision dramatically expanded presidential war powers, establishing that presidents could take military action to repel sudden attacks or suppress rebellion, even without prior congressional authorization. The dissent warned. This gave presidents dangerous unilateral war-making authority. Case 27, Ex parte Milligan, 1866. During the Civil War, President Lincoln suspended habeas corpus and authorized military tribunals to try civilians in areas far from actual fighting. Lambden Milligan, an Indiana civilian and Confederate sympathizer, was arrested, tried by a military commission, convicted of conspiracy, and sentenced to death. Milligan petitioned for habeas corpus, arguing that as a civilian in a state where civil courts were functioning, he had a constitutional right to trial by jury in civilian courts. The Supreme Court's decision came after the war ended but resonated powerfully. Justice Davis wrote that the Constitution's protections apply in wartime and peacetime alike. Military tribunals could try civilians only in actual theaters of war, where civil courts couldn't function. Indiana had functioning courts throughout the war. Milligan was entitled to his constitutional rights: trial by jury, confrontation of witnesses, and all protections of criminal procedure. The opinion declared that the Constitution of the United States is a law for rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men, at all times, and under all circumstances. Even in emergencies, the government remains bound by constitutional limits. Presidents cannot suspend constitutional rights through proclamation. The decision established crucial limits on executive power during wartime and protected civilian judicial authority from military encroachment. Case 28, the Slaughterhouse Cases, 1873. Louisiana's legislature granted a single corporation, a 25-year monopoly over all slaughterhouse operations in New Orleans, ostensibly for public health reasons. The law required all other butchers to use the favored company's facilities and pay its fees. Hundreds of independent butchers sued, arguing the monopoly violated their rights under the newly ratified 14th Amendment. They claimed it violated their privileges or immunities as citizens, denied them equal protection, and deprived them of property without due process. This was the Supreme Court's first interpretation of the 14th Amendment, adopted in 1868 to protect freed slaves. Justice Miller's majority opinion took a narrow view. He held that the Privileges or Immunities Clause protected only a limited set of rights related to national citizenship, like access to federal courts and navigable waters, not the broad spectrum of civil rights or economic freedoms. Most traditional rights remained under state protection. The court rejected the due process and equal protection arguments as well. The decision effectively gutted the Privileges or Immunities Clause, reducing it to near meaninglessness. This narrow interpretation allowed states to pass discriminatory laws and limited federal power to protect civil rights. The ruling hamstrung Reconstruction efforts and permitted Southern states to enact Jim Crow laws. Not until the 20th century would the court revitalize the 14th Amendment's protections through other clauses. Case 29, Bradwell v. Illinois, 1873. Myra Bradwell, a woman of extraordinary accomplishment, had studied law, passed the bar examination, edited the premier legal publication Chicago Legal News, and drafted legislation that Illinois adopted. When she applied for admission to the Illinois bar, the state Supreme Court denied her application solely because she was a woman. Bradwell challenged this under the 14th Amendment's Privileges or Immunities Clause, arguing that the right to practice one's profession was a fundamental privilege of citizenship that states couldn't deny based on sex. The Supreme Court unanimously rejected her claim. Justice Miller's opinion, citing the recent slaughterhouse cases, held that the right to practice law was not a privilege of national citizenship protected by the 14th Amendment. Justice Bradley's concurrence went further, embracing Victorian gender ideology explicitly. He wrote that the natural and proper timidity and delicacy, which belongs to the female sex, evidently unfits it for many of the occupations of civil life. Bradley declared that a woman's paramount destiny and mission was as wife and mother. The harmony of the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. The decision reflected and reinforced pervasive discrimination against women in law, medicine, and other professions, barriers that wouldn't fully crumble for another century. Case 30, Minor v. Happersett, 1875. Virginia Minor, president of the Woman's Suffrage Association of Missouri, attempted to register to vote in St. Louis. Reginald Happersett, the registrar, refused to register her because she was a woman. Minor and her husband sued, arguing that as a citizen, voting was one of the privileges or immunities of citizenship protected by the 14th Amendment. States couldn't deny this fundamental right based on sex. The Supreme Court's unanimous decision crushed hopes that the 14th Amendment would secure women's suffrage. Chief Justice Waite acknowledged that women were indeed citizens, but held that citizenship didn't automatically confer the right to vote. Voting rights, the court ruled, were not inherent privileges of national citizenship, but rather were defined by states. The Constitution, Waite noted, never used the word male until the 14th Amendment's penalty provision for denying men's suffrage. This suggested the framers understood states controlled voting qualifications. If women's suffrage was to be achieved, it required specific constitutional amendment or state action, not judicial interpretation. The decision made clear that women's suffrage would require a political solution. Suffragists redoubled their efforts, state by state and nationally. It would take another 45 years of organizing, protests, and advocacy before the 19th Amendment finally granted women the vote in 1920. Case 31, United States v. Cruikshank, 1876. Following a disputed 1872 election in Louisiana, armed white supremacists attacked a group of black citizens and Republican office holders defending the Grant Parish Courthouse. In what became known as the Colfax Massacre, over 150 black men were killed, many after surrendering. William Cruikshank and other perpetrators were prosecuted under the Enforcement Act of 1870 for conspiring to deprive victims of their constitutional rights, including rights to assemble and bear arms. The Supreme Court overturned the convictions on technical grounds but established destructive precedents. Chief Justice Waite held that the 14th Amendment didn't grant new rights but only prohibited states from infringing existing rights. Crucially, it provided no protection against private action, only state action. The First Amendment's right to assemble applied only against federal government infringement, not state or private interference. The Second Amendment similarly restrained only federal action. Since the indictments didn't allege that defendants acted under state authority, the federal government couldn't prosecute them. State courts would have to handle such crimes. This interpretation eviscerated federal civil rights enforcement. It meant the federal government was powerless to protect black citizens from private violence. The exact terror tactics that white supremacist groups used to overthrow Reconstruction governments. The decision effectively ended federal prosecution of Klan violence, abandoning freed slaves to state protection that often came from the very officials complicit in terrorizing them. Case 32, United States v. Reese, 1876. William Garner, a black citizen of Kentucky, attempted to pay his poll tax and register to vote. Two election inspectors, Hiram Reese and Matthew Fouché, refused to accept his payment or register him solely because of his race. Federal prosecutors charged them under the Enforcement Act of 1870, which criminalized denying citizens the right to vote based on race. The inspectors argued the law exceeded Congress's authority under the 15th Amendment. Chief Justice Waite's opinion gutted federal voting rights enforcement. He ruled that the 15th Amendment didn't grant anyone the right to vote, but merely prohibited denying voting rights based on race, color, or previous condition of servitude. States retained plenary power to set voting qualifications, including literacy tests, poll taxes, and property requirements. Congress could only prohibit racial discrimination, not regulate voting generally. Two sections of the Enforcement Act were struck down as too broad, and without them, the remaining provisions couldn't support the prosecution. This narrow interpretation left enormous loopholes. States could enact facially neutral voting restrictions, like literacy tests or poll taxes, that disproportionately disenfranchised black voters without explicitly mentioning race. Combined with Cruikshank, the decision crippled Reconstruction and opened the door to systematic disenfranchisement that lasted nearly a century. The federal government abandoned Southern black voters to Jim Crow's tender mercies. Case 33, Hall v. DeQueer, 1878. Louisiana's Reconstruction government passed a law in 1869 prohibiting racial segregation on common carriers operating in the state. Josephine DeQueer, a black woman, purchased a first-class steamboat ticket from New Orleans to Hermitage, Louisiana. The steamboat captain, operating under the line's segregation policy, refused to allow her in the first-class cabin reserved for white passengers. DeQueer sued under Louisiana's anti-discrimination law. The Supreme Court struck down Louisiana's law as an unconstitutional burden on interstate commerce. Chief Justice Waite held that because the steamboat traveled between Louisiana and Mississippi, it engaged in interstate commerce requiring uniform regulation. Louisiana couldn't require integration on vessels that would enter states requiring segregation. Compelling carriers to provide mixed facilities on interstate journeys imposed an undue burden on commerce. If each state could impose its own rules on interstate carriers, the resulting patchwork would be unmanageable. The decision prevented states from prohibiting discrimination on interstate carriers. Yet in Louisville, New Orleans, and Texas Railway v. Mississippi, 1890, the court upheld state-mandated segregation on interstate carriers, finding no Commerce Clause violation. This inconsistency revealed the court's commitment to segregation over logical consistency. States couldn't require integration, but could require segregation. The decisions helped entrench Jim Crow's separate but equal doctrine that Plessy v. Ferguson would formalize in 1896. Case 34, Strawder v. West Virginia, 1880. Taylor Strawder, a black man, was indicted for murder in West Virginia. State law explicitly prohibited black citizens from serving on juries. Strawder sought to remove his case to federal court, arguing that the all-white jury pool violated his rights under the 14th Amendment. The Supreme Court's decision marked a rare victory for civil rights during this era. Justice Strong held that the 14th Amendment's Equal Protection Clause prohibited states from excluding black citizens from jury service based solely on race. The amendment's purpose was to prevent discrimination against the freed slaves and ensure equal treatment under law. Excluding black citizens from juries denied them equal protection by permitting their rights to be adjudicated by institutions from which they were systematically excluded. Strong emphasized that a black defendant's conviction by a jury from which all members of his race were excluded raised questions about the trial's fairness and impartiality. The decision established that racial discrimination in jury selection violated equal protection. However, the court's companion decision in Virginia v. Rives, 1880, severely limited this protection. While explicit statutory exclusion was forbidden, prosecutors could still exclude black jurors through discretionary challenges, and defendants faced an enormous burden proving discrimination when exclusion wasn't written into law. Southern states simply shifted from explicit exclusion to discriminatory administration, maintaining all-white juries for generations while technically complying with Strawder. Case 35, Civil rights cases. 1883. Congress passed the Civil Rights Act of 1875, prohibiting racial discrimination in public accommodations like hotels, theaters, and transportation. The law declared that all persons were entitled to full and equal enjoyment of these facilities regardless of race. Several black citizens sued after being denied service or segregated in theaters, hotels, and railroads. The Supreme Court struck down the Civil Rights Act in a decision that devastated Reconstruction and enabled Jim Crow. Justice Bradley held that the 14th Amendment prohibited only state action, not private discrimination. Section 1 stated no state shall, not no person shall. Congress's enforcement power under Section 5 was therefore limited to correcting state violations, not regulating private conduct. A hotel owner's refusal to serve black customers was private action beyond federal reach. Bradley dismissed the argument that businesses serving the public exercised quasi-governmental functions subject to constitutional constraints. He also rejected claims that discrimination was a badge of slavery Congress could prohibit under the 13th Amendment, arguing that refusing hotel accommodations didn't reduce anyone to slavery. Only Justice Harlan dissented, arguing that public accommodations were thoroughly regulated by state law and that discrimination in such businesses perpetuated slavery's effects. The decision left black citizens without federal protection against discrimination, enabling the segregation system that would dominate the South for 80 years. Not until the Civil Rights Act of 1964 would Congress successfully prohibit private discrimination in public accommodations. Case 36, Hurtado v. California, 1884. Joseph Hurtado was charged with murder in California without a grand jury indictment. Instead, prosecutors used California's information procedure, where the prosecutor filed charges after a preliminary hearing before a magistrate. Hurtado argued this violated the Fifth Amendment, which requires that no person shall be held to answer for a capital crime, unless on a presentment or indictment of a grand jury. The case tested whether the 14th Amendment's Due Process Clause required states to follow all the specific procedures in the Bill of Rights. Justice Matthews, writing for the majority, held that the 14th Amendment didn't require states to use grand juries. Due process was flexible, not frozen in Anglo-Saxon legal history. States could modify procedures as long as they provided fundamental fairness. California's preliminary hearing provided adequate protection. A judicial officer reviewed evidence and determined probable cause before charging. This satisfied due process, even though it wasn't a grand jury. Justice Harlan dissented, arguing that due process meant the process due under established law and tradition. Grand juries were a fundamental right that states couldn't abolish. The majority's flexible approach to due process would eventually enable selective incorporation of most Bill of Rights protections against states. But in 1884, it meant states could ignore many federal constitutional protections. The decision allowed states to experiment with criminal procedures, but also permitted them to provide fewer protections than the federal government. Case 37, Yick-Wo v. Hopkins, 1886. San Francisco passed ordinances requiring permits for laundries operating in wooden buildings. The Board of Supervisors had total discretion to grant or deny permits. They granted permits to all but one of 80 white-owned laundries, but denied permits to all 200 Chinese-owned laundries. Despite many Chinese establishments having operated safely for years, Yick-Wo, operating his laundry for 22 years in the same building, was denied a permit and arrested for operating without one. The Supreme Court issued a landmark decision on equal protection. Justice Matthews held that while a law might be facially neutral, appearing to treat everyone equally, its discriminatory application violated equal protection. The administration of San Francisco's law revealed intentional discrimination, granting virtually all white applications while denying virtually all Chinese applications, demonstrated a discriminatory purpose. The 14th Amendment protected all persons, not just citizens, so Chinese immigrants were entitled to equal protection. Matthews wrote that the amendment's equal protection of the laws is a pledge of the protection of equal laws, prohibiting both discriminatory laws and discriminatory enforcement of neutral laws. This established the principle that facially neutral laws, administered in a discriminatory manner, violate equal protection. Despite this promising decision, the court generally failed to protect Chinese immigrants from discrimination. Not until Brown v. Board of Education would the court again meaningfully enforce equal protection against discrimination. Case 38, Munn v. Illinois, 1877. Ira Munn and George Scott operated grain warehouses in Chicago, a major hub for grain storage and distribution. Illinois passed a law regulating grain elevator rates, setting maximum charges for storage. Munn challenged the law as an unconstitutional deprivation of property without due process and an interference with interstate commerce. The case tested whether states could regulate private businesses. Chief Justice Wade upheld the regulation, establishing the doctrine of businesses affected with a public interest. He explained that when private property is affected with a public interest, it ceases to be juris privati only and can be regulated by the state. Grain elevators were essential to the public welfare. Farmers depended on them, and their monopolistic position in Chicago gave them immense power over prices. Such businesses weren't purely private, but served public functions justifying regulation. Wade acknowledged that regulation could be unwise or oppressive. But for protection against abuses by legislatures, the people must resort to the polls, not to the courts. The decision validated progressive era, reforms allowing states to regulate utilities, railroads, and other businesses serving public needs. However, it left uncertain which businesses were affected with a public interest. This ambiguity would fuel decades of litigation. The decision marked a shift toward accepting economic regulation, but preserved property rights where businesses weren't sufficiently public in nature. Case 39, Wabash, St. Louis and Pacific Railway Company v. Illinois, 1886. Illinois passed a law prohibiting railroads from charging more for short hauls than long hauls on the same line, aiming to prevent discrimination against farmers shipping locally. The Wabash Railroad charged more to ship goods 86 miles within Illinois than for a 314-mile journey that crossed state lines. Illinois sued to enforce its law. The railroad argued that the shipments crossed state lines, placing them beyond state regulatory power. The Supreme Court agreed with the railroad, striking down Illinois' law as applied to interstate shipments. Justice Miller held that even though the discriminatory rates injured Illinois farmers, regulating interstate commerce rates required national uniformity. A railroad couldn't comply with conflicting rate regulations from every state it traversed. Only Congress could establish uniform rules for interstate railroad rates. The decision effectively nullified state regulation of railroad rates on interstate routes, creating a regulatory vacuum. Railroads were free to discriminate, charge monopolistic rates, and abuse their economic power without legal constraint, because Congress hadn't yet acted. Public outrage over railroad abuses, combined with the regulatory gap created by Wabash, pushed Congress to pass the Interstate Commerce Act of 1887, creating the Interstate Commerce Commission, the first federal regulatory agency. The case thus inadvertently sparked the modern administrative state by demonstrating that effective regulation of interstate commerce required federal action. Case 40, Reynolds v. United States, 1879. George Reynolds, a Mormon living in Utah Territory, was convicted of bigamy, having 2 wives simultaneously. He challenged his conviction, arguing that plural marriage was a religious duty for Mormons, and prosecuting him violated his First Amendment right to free exercise of religion. The case presented the first significant Supreme Court interpretation of the Free Exercise Clause. Chief Justice Waite's opinion distinguished between religious belief and religious action. The First Amendment protected beliefs absolutely. Government couldn't punish thoughts or opinions. However, religious action wasn't absolutely protected. If every person could violate laws when their religion commanded it, every citizen might become a law unto himself, and government could exist only in name. Laws prohibiting harmful conduct remained valid even if a religion commanded that conduct. Waite compared polygamy to practices like human sacrifice. Both might be sincere religious beliefs, but government could still prohibit them. He cited extensive evidence that Western civilization considered polygamy contrary to social order, leading to despotism and female degradation. The decision established that neutral laws of general applicability could be enforced even when they burdened religious practice. This framework would govern free exercise analysis for over a century, until Employment Division v. Smith, 1990. While the reasoning enabled prosecution of Mormons, it also protected religious minorities from discrimination. Laws specifically targeting a religion would be unconstitutional. Case 41, Pennoyer v. Neff, 1878. Marcus Neff hired J.H. Mitchell, a lawyer, for legal services in Oregon. When Neff didn't pay, Mitchell sued him. Unable to locate Neff, Mitchell served notice by publication in a newspaper rather than personally delivering it. The court awarded Mitchell a judgment and authorized selling Neff's Oregon land to satisfy it. Mitchell bought the land and sold it to Sylvester Pennoyer. Years later, Neff sued Pennoyer, claiming the original judgment was void because the court lacked jurisdiction over him. Newspaper publication wasn't sufficient notice. Justice Field's opinion revolutionized civil procedure and due process. He held that courts could assert jurisdiction over persons in only 2 ways: physical presence in the state at the time of service, in personam jurisdiction, or through attachment of property located in the state at the lawsuit's commencement, in rem or quasi, in rem jurisdiction. Service by publication alone, without seizing property first, was insufficient to establish jurisdiction. The Due Process Clause required that before depriving someone of property, that person must receive notice reasonably calculated to inform them of the proceedings and an opportunity to be heard. Newspaper publication, when the defendant wasn't a resident and had no property in the state, didn't satisfy due process. The original judgment was void, so Pennoyer held no title. The decision established territorial limits on state court jurisdiction and notice requirements that shaped civil procedure for a century. Case 42, Pollock v. Farmers Loan and Trust Company, 1895. In 1894, Congress passed an income tax of 2% on incomes over $4,000 to help fund government operations during an economic depression. Charles Pollock, a shareholder in Farmers Loan and Trust Company, sued to prevent the company from paying the tax, arguing it violated the Constitution's requirement that direct taxes be apportioned among states by population. The Supreme Court's decision, one of its most politically controversial, struck down the income tax in a 5-4 vote. Chief Justice Fuller held that taxes on income from property were effectively taxes on the property itself, making them direct taxes requiring apportionment. Since the income tax wasn't apportioned by population, it was unconstitutional. The dissent, led by Justice Harlan, argued vehemently that the decision frustrated popular will, protected the wealthy from taxation, and ignored precedent. Justice Brown warned the decision might leave the government unable to fund itself during emergencies. The ruling ignited fierce political battles. Progressives denounced the court as protecting plutocratic interests. The decision made income taxes impossible without constitutional amendment. After years of political organizing and advocacy, the 16th Amendment was ratified in 1913, explicitly authorizing Congress to lay and collect taxes on incomes without apportionment. Pollock stands as one of the Supreme Court decisions directly overturned by constitutional amendment. Case 43, United States v. Wong Kim, Ark, 1898. Wong Kim Ark was born in San Francisco to Chinese immigrant parents who maintained a permanent domicile and business in the United States. In 1895, after visiting China, immigration officials denied his re-entry, claiming he wasn't a U.S. citizen because his parents were Chinese nationals. The 14th Amendment's opening sentence declares, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." The case tested whether children of non-citizen immigrants born on U.S. soil were citizens. Justice Gray's opinion examined English common law and historical practice, concluding that the 14th Amendment embraced the ancient principle of jus soli, birthright citizenship based on place of birth. Every person born in the United States was a citizen, unless they fell into narrow exceptions: children of foreign diplomats, children born on foreign public vessels, or children born to enemy forces occupying U.S. territory. Wong's parents, though Chinese nationals ineligible for citizenship themselves, were subject to U.S. jurisdiction. Their son, born on U.S. soil, was therefore a citizen regardless of his parents' status or race. The dissenters argued this interpretation would allow children of any foreign parents, even those hostile to America, to claim citizenship. The majority prevailed, establishing birthright citizenship as fundamental American law. The decision has profound ongoing significance in debates over immigration and citizenship, particularly regarding children born to undocumented immigrants. Case 44, United States v. E.C. Knight Company, 1895. The American Sugar Refining Company controlled 65% of U.S. sugar refining capacity. It acquired the E.C. Knight Company and 3 other competitors, giving it control of 98% of all sugar refining in America, a virtual monopoly. The United States sued under the Sherman Antitrust Act of 1890, which prohibited contracts or combinations in restraint of trade. The government argued that this massive consolidation violated the act and should be dissolved. Chief Justice Fuller's decision dramatically limited federal antitrust power. He held that manufacturing wasn't commerce under the Commerce Clause. Commerce meant trade, buying and selling, not production. Sugar refining was manufacturing, which occurred before trade, and was therefore a local activity subject to state regulation. The fact that refined sugar was then sold in interstate commerce didn't transform manufacturing into commerce. Only direct effects on interstate commerce triggered federal power. Indirect effects, however significant, remain beyond federal reach. Even a monopoly affecting 98% of an industry was, in the court's view, a local matter. The decision effectively neutered the Sherman Antitrust Act for a decade. Monopolies and trusts flourished because states lacked effective power to regulate interstate businesses, while federal power was interpreted too narrowly to reach them. Not until the Progressive era would the court adopt a broader reading of commerce power. enabling effective federal regulation of monopolies and anti-competitive practices that actually dominated national markets. Case 45. In R.E. Debs, 1895. Eugene V. Debs, president of the American Railway Union, led a nationwide railroad strike in 1894 to protest wage cuts. The strike paralyzed rail traffic, particularly in Chicago, a major hub. The federal government obtained an injunction ordering strikers to cease interfering with railroads carrying U.S. mail and engaging in interstate commerce. Debs defied the injunction, continuing to lead the strike. He was arrested and jailed for contempt of court. Debs challenged his imprisonment, arguing federal courts lacked authority to issue such an injunction without statutory authorization, and his imprisonment without jury trial violated his rights. The Supreme Court unanimously upheld the injunction and Debs's imprisonment. Justice Brewer held that the federal government possessed inherent power to protect interstate commerce and mail delivery, powers derived from its sovereignty. Courts could issue injunctions to remove obstructions to federal functions, even without specific statutory authority. The contempt proceedings, being civil rather than criminal in nature, didn't require jury trials. The decision established federal injunctions as a powerful weapon against labor strikes. It demonstrated that judicial power could effectively suppress labor organizing when workers' collective action threatened business interests or interstate commerce. Employers quickly adopted this strategy, obtaining federal injunctions to break strikes by criminalizing collective action. The decision contributed to violent confrontations between labor and management and sparked progressive outrage that eventually led to greater legal protections for organized labor in the 20th century.